Now, for our second keynote speaker, it's now my privilege to introduce to you our next keynote, Dr. Andrew Bickerdike. Andrew is well known to our network and a long-standing and respected member of it. He is the CEO of Relationships Australia Victoria and the Board Chair of Relationships Australia National. He holds tertiary qualifications in both economics and psychology and a doctorate in dispute resolution. Andrew has experience and specialist training in individual, marital and family therapy and family dispute resolution, and has practiced as a psychologist, mediator and family dispute resolution practitioner for over 20 years. Today I invite him to the stage in a different capacity as part-time Commissioner of the Australian Law Reform Commission to assist in the review of the family law system. We were extremely pleased to see Andrew's appointment to this high-level and critical decision-making position in the ALRC. Not only is he exceptionally well credentialed to take on this role, but in the ALRC world, predominantly influenced and driven by lawyers and the legal profession, we all know that Andrew is an extremely capable and strong advocate. I would also like to thank Andrew for stepping up into this keynote role following the resignation from the ALRC of Professor Helen Rhodes. Helen has shared with us what an extremely difficult decision it was for her to make, but that she understandably has had to put her energy and focus into her health. In previous discussions preparing for this session, Helen was reflecting how much she was looking forward to being in Cairns, because she was also one of the people who was here at our inaugural conference 10 years ago. So Andrew will address us today on behalf of the ALRC, and so could we please warmly welcome Dr. Andrew Bickerdike to the stage. Thank you.
Thank you, Michael. I'd like to acknowledge the traditional custodians of the land that we're meeting on today and pay my respects to their elders past, present and emerging. I too was someone who was at the first conference 10 years ago. I remember it well. It was an excellent conference, and I'm sure you'd agree with me the one that we're experiencing at the moment is also an excellent conference. I think I've been to every one since, and it's a great opportunity for the sector to learn from its challenges, to interact with each other and to argue points. And I think we should be very grateful for the FRSA for putting on such wonderful conferences for us. When I came here the first time, I brought my children, who were very young at the time, and we had a wonderful time enjoying Cairns and the Cairns environment. This time I haven't been so lucky. I have a son who's currently sitting his last exam right this minute as a Year 12 student. So if I take a call during my speech, you'll have to forgive me. But it is rather exciting to have got to that stage of life. So yes, I'm here representing the Law Reform Commission and not representing the sector. But of course I have some biases that I'll be trying to keep under control as we go through this presentation. So the law reform process is a common process that they apply to every reference they get, so I thought I'd just remind you of what that process is. There's a terms of reference that are initiated. This time it was done in 2017 in September. That leads to the Law Reform Commission doing some research, some consultation, and then an issues paper is released, and that issues paper is largely putting on the table the issues that the sector and the consultations and the references have alluded to. And then there's a call for submissions to that issues paper. Those submissions are also augmented by additional consultations as the Law Reform Commission goes around and speaks to particular bodies and organisations. Then there's a review of the submissions and the combination of responses, consultations, submissions, and the initial reference leads to a discussion paper, which has within it proposals that are proposals to solutions that have been identified. Mind you, that discussion paper is by no means a final product. The discussion paper is very much a discussion paper, and it is looking for further input and further consultation. And so we are in the stage of the discussion paper having been, the submission period for the paper having ceased, and we're now in that last second last blue box there, where the submission paper and the submissions to the discussion paper are being reviewed, but it doesn't mean that there aren't ongoing consultations. And so you could actually regard this as a consultation today. There'll be time for questions. I'm hoping we have time for questions and views to be expressed. And I know there was a session run 2 days ago, I think, a family law focused workshop where the discussion paper was aired and discussed, and there was some strong views, I think, as I've heard expressed at that time, so that's good, and that's happening today. There are people from the Law Reform Commission in the room today, lots of them. Probably the person sitting next to you is a secret agent, and they're here to collect your views and to use the comments they hear there to inform the final report. They're actually mainly here to make sure I don't say the wrong thing. So, the discussion paper 86. I've got no idea why it's 86. I presume it's the 86th discussion paper, or it could be, as you are well aware, lawyers enjoy putting numbers at the beginning and the end of sentences. Have you noticed that? So I imagine they feel more secure with a number at the end of the discussion paper. So, as the Senator talked about, there was 124 proposals for change in the discussion paper, and there were 31 specific questions. The discussion paper responded to the terms of reference, as I said, and it took into account nearly 500 consultations, 500 submissions, which is an enormous amount of submissions, and reflects the interest of the sector and the interest of the community in this particular topic, and more than 100 consultations, direct consultations around the country. That figure would actually be understating it now. There'd be well over that amount of consultations that have occurred, and they're ongoing. It also takes into account an enormous amount of research. You'd be aware this is a sector that's been evaluated, reviewed, reported on numerous times in recent years, and there's been very many research reports. The Institute of Family Studies have done a number of significant research projects. The Family Law Council has provided many reports, and so there's a lot of other data and information that the Law Reform Commission can draw on. So the submissions were due on the 13th of November, and the final report is due on the 31st of March. So just briefly, I'd like to go over the terms of reference just to remind you where this all came from. So the ALRC was asked to consider the appropriate role of the family law system, so the entire system in contemporary Australia, and how it could be more responsive. It included questions about affordability, safety, substantive law, how the system integrates with other systems, and its culture, its structure, and its governance. It also asked whether the system's processes for resolving disputes were well adapted to meet the needs of separated families. It paid a particular attention to the involvement of children in family law processes. It talked about integrated services for families with complex needs. It referred to the competencies and skills of the family law professionals, and it talked about the entire governance of the system and its accountability mechanisms. So it's a very broad reference that requires the Law Reform Commission to attend to numerous issues and numerous aspects of the system. It's a systemic review. So the key principles that underpinned the discussion paper are worth noting. It's a client-centred approach to developing reform, and I think that's an important point. It's a client-centred approach. The Law Reform Commission is looking at it from the lens of the client. And it's been quite interesting for me because doing this work, when I step into the role as a commissioner, I need to step out of my role as a mediator, as a manager, even as a community sector worker. And that's quite refreshing in a way, because I just look at it from where the client sits. Now, we like to all think we do that, but at the end of the day, we carry our own baggage as well, where we come from, our own biases. And this is not looking at it from the point of view of the community sector. It's not looking at the point of view of family lawyers, from the point of view of courts, it's looking at the point of view of clients. So the key principles that were emphasised were safety and well-being of children and families, the need for collaboration and coordination, accessibility, non-adversarial approaches, a strengthened focus on children and young people, particularly their safety, their needs, and as I'll talk about later, their participation, and an overarching need to build trust in the system. What came through from many of the submissions and many of the consultation, there's been an erosion of trust in the family law system. And so it's clearly an objective of the outcomes of this review is you can't build trust overnight, of course, but you need to be able to build a system that can gather trust over time. And the other key principle is to treat the system from a public health approach, recognising that separated families have varying levels of need. I'd like to just dwell on that for a moment, what is actually meant by a public health approach. It's an approach that aims to prevent problems from occurring in the first place, to quickly respond to problems if they do occur, and to minimise any long-term effects and prevent reoccurrence. Primary interventions such as public awareness and education campaigns are delivered to the whole community in order to provide support before problems occur. Typically delivered in community settings such as schools, community health providers and the media. The point of primary interventions is to shift the risk profile positively for the entire relevant population. In the child protection domain, for an example, this means aiming to have fewer children in need of more intensive secondary or tertiary services, such as removal from their family by child protection agencies. In the family law domain, this will mean fewer families needing to access secondary services. So they can access support services, they access information, but they won't necessarily be needing to access tertiary services or secondary services, court services, family dispute resolution services. Secondary interventions target people where there is a higher risk of harm, using the research evidence of risk indicators to identify appropriate strategies. In the child protection space, again, for an example, risk indicators for child harm can include poverty, parental mental health issues, parental conflict, family violence, parental drug and alcohol misuse. So secondary interventions in that area might include delivery programs to support parents living in disadvantaged areas. Tertiary interventions are designed to reduce long-term implications of harm and to prevent reoccurrence. In child protection matters, tertiary services target families where child abuse or neglect has already occurred or is believed to have occurred. So how does this apply to the family law system? So we know around 50,000 children experience the separation of their parents each year. The main influence on well-being of outcomes for children in separated families are the same as for those in non-separated families. Financial disadvantage, exposure to parental conflict, exposure to family violence, exposure to less than optimal parental behaviours. Now we know the vast majority of separated parents report positive relationships with their former partner, as well as positive levels of well-being of their children. For a public health perspective, therefore, it's evident that many separating families will only require support of a primary nature, such as clear information about where and how to access legal information. However, research shows that significant proportions of family law system clients who use its formal dispute resolution pathways, so family dispute resolution, access to lawyers, access to the courts, are affected by characteristics associated with risk and vulnerability, and particularly among those who engage with the courts. So we know that the level of family violence, for example, in the community is lower than those clients that are separating, and those clients that are accessing family dispute resolution services have higher incidence, prevalence of family violence, and those that access courts have even higher levels. And as you go through that spectrum, the amount of multiple issues of vulnerability increase. So it's evident that the family law system is delivering services to families at a time of heightened vulnerability, and on this basis, interaction with the family law system offers a critical opportunity for interventions with families that can potentially reduce the factors that might compromise children's well-being. So firstly, just briefly, because I won't spend much time on this, at the primary level of intervention, the ALRC is proposing the development of a national education and awareness campaign to promote public awareness of the law and sources of information, advice and support for separating families. This would be supplemented by an accessible, authorised information package and by simplifying the Family Law Act so that average punters like you and I can understand it. It would also be supported by the building of referral relationships between family law systems and universal services and a first port of call services for people affected by family violence. Together, this set of proposals aim to ensure that separating families, including children and young people, know how and where to get assistance they need. Other key proposals that I'll refer to today is the Families Hubs. That's one of the key secondary interventions. Enhanced family dispute resolution is another key component of the proposals. Some suggestions for changing some court processes. Some key suggestions for the participation of children and young people, and strengthening governance, a proposal for a Family Law Commission. So I'm looking to focus on those ones there, and we'll see how we go with time, because I am keen to allow commentary and questions. So I'll work from top to bottom, and if we don't get down to the bottom ones, the discussion paper itself goes into those proposals in great detail. And can I say I've just chosen proposals that I think would be of interest to this audience. Clearly there is many, many more proposals and much more detail within the document, the discussion paper, and I'm sure all of you have read it extensively. So, integrated pathways for advice and support. Families Hubs. As a secondary level response, the ALRC proposes to build on the work pioneered by the FRCs by establishing community-based families hubs to provide separating families with a visible contact point for accessing a range of advice and support services in the one place. This initiative would bring together a team of on-site embedded workers from a range of local services, including legal assistance services, family relationship services, specialist family violence services, financial counselling and housing assistance services, and specialist services for children and young people. Many families who seek the assistance from the family law system will have a range of legal and support needs. This may include a need for housing assistance, financial assistance, health and therapeutic support needs, in addition to a need for legal advice about parenting or child support. Some families present with needs arising from experiencing family violence, mental health issues, or drug and alcohol misuse issues. These exacerbate their separation-related needs. So submissions to the inquiry, this is submissions to the issues paper, indicated that family law clients are often frustrated by the disconnected nature of the service system they encounter, where family law and other services tend to operate in silos. The submissions and the previous research also suggests, or also point to a number of barriers affecting the ability of families to access the range of services they need, and to the associated safety and well-being risks for clients and parents. One possibility would involve expanding the role of the FRCs, of course. In 2006, a network of FRCs was developed across the country with the aim of providing a single front door entry point to the family law system for separating families outside the courts. If you recall the terminology around the time when the FRCs were being set up, it was around no wrong door. So while the FRCs were designed to act as the front door to services for separated families, they were not intended to operate as a one-stop shop. Rather than housing a wide range of services on site, FRCs were designed to link clients with services through referrals. So as a result, many clients are left to identify and access the services appropriate to the needs without assistance. The risk of this is that families will disengage from the system or receive assistance in only one sphere. For example, legal advice. They might come to an FRC, they might be assessed as being inappropriate for FDR. They might have a partner who's not willing to come. They're referred for legal advice, but there's no continuance of care after that. In response, stakeholders suggested the need for a central hub or problem-solving centre that incorporates a needs assessment role with both navigation assistance and coordination of service delivery. You could call that a case management type intervention to assist people to safely and seamlessly access the range of services they may need when contemplating or experiencing separation. The proposed family hubs share some of the features that drove the development of the FRCs. As with the FRCs, family hubs are intended to be community-based, clear entry points to the range of services that separated families may need. However, the families hubs would also have some important distinctions. So the FRCs, as I said before, were designed to link families with services through information referral. Family hubs are designed to play a more active role, to provide services and to assist families to navigate and engage with existing services. This would be done through an intake process to identify a person's safety, support and advice needs. Clients would then be linked to on-site workers from relevant services in the one place. The families hubs would also have a case management function to ensure clients with complex needs do not fall through the gaps when they leave the families hubs. So the argument is there needs to be a continuing contact and case management of clients. So in this way, the services presented by the families hubs would extend beyond those services currently provided by FRCs. That include perhaps legal assistance services being embedded within them, specialist family violence services, addiction services, financial counselling, housing assistance services. In some communities, they could also include culturally specific services, such as migrant resource centres or services provided by Aboriginal-controlled organisations. It's proposed that the families hubs would build on and support FRCs rather than replace them. Workers from FRCs could be embedded in families hubs. In selecting locations for the families hubs, the ALRC suggests the government should identify places of convenience for separating families. For example, hubs may be housed in, within, or adjacent to existing FRCs, legal aid commissions, the newly established Orange Door support and safety hubs in Victoria, or state and territory magistrates' courts. So moving on to the next area for integrated pathways, we have the expansion proposal to expand the family advocacy and support services, what's commonly called as the FAS services. So just to give you a little bit of background, the FAS services were created in the middle of 2017. The Australian government announced the FAS in each state and territory. It's designed to provide integrated duty legal services and support services to families affected by family violence who are in the family courts. The FAS is currently running in 23 locations, 23 court registries, and has funding until 2019. And it's currently being evaluated by independent evaluators. While each FAS assists families affected by family violence and is delivered and coordinated by legal aid commissions and combines duty lawyers and specialist family violence support workers using a team-based approach. But the legal aid commissions in each state and territory have developed their own models, so none of them are identical. So to ensure that the separating families who enter the family law system through the courts are also provided with navigation assistance, legal and other supports and case management as needed, the ALRC proposes an expansion of the existing FAS services in each state and territory. The model proposed includes an information and referral officer, 2 legal services and 2 support services, giving the FAS the capacity to assist both parties to a dispute. One of the legal services and one of the support services should be provided by services with family violence expertise, and the expanded FAS model should provide duty legal services and support services to people affected by family violence, as well as to people who may not be affected by family violence, but have other complex needs. To address the risk of client safety risk, complex needs and vulnerable families through the gaps, it's proposed that the FAS support services also have a capacity to provide case management services needed. Again, so this is actually saying, well, You can't provide a service to these clients and then wash your hands of them. There needs to be an ongoing support and navigation case management once they've left the service. The level and duration of support provided by FAS, including case management support, should be flexible depending on the client's level of need and vulnerability. So there's a brief overview of the proposal to increase and enhance the FAS services. So another area of reform that's proposed is the enhancement of family dispute resolution services. There's three main areas of focus: the development and delivery of FDR for property and financial matters, and as you've heard today, that there's been a recent announcement from the government for extra support for property dispute resolution in FRCs. The expansion of lawyer-assisted dispute resolution models for parenting and property matters, and specific models to meet the needs of Aboriginal and Torres Strait Islander communities and cultural and linguistically diverse families, LGBTIQ families, and families where parents or children may be affected by disability. So first, property and financial matters. Patterns of service have changed significantly since the introduction of the stronger legislative support for family dispute resolution in children matters in 2006. At that time, court filings in children matters dropped by 25% and the use of FDR increased significantly. FDR has gained increasing acceptance, and more sophisticated models, such as legally assisted dispute resolution, are seen as suitable for even the more complex cases. However, by contrast, the frequency for property and financial matters is not a mandatory requirement. However, research and evidence shows that most separating parents have modest incomes and asset pools. That demonstrates a need for greater access to affordable dispute resolution mechanisms. In 2014, the Productivity Commission Access to Justice report identified a missing middle in terms of cost-effective avenues for property and financial arrangements after separation. Its analysis concluded that court pathways were too expensive for many separating couples, and that increased access to FDR would address this gap. Various academic research efforts, including research by the Institute of Family Studies, have supported these recommendations from the Productivity Commission, as did many of the submissions to the issues paper. So the proposal responds to both the support for greater use of FDR in property and financial matters and to concerns about adverse consequences. There's a proposal to actually replicate the compulsory FDR for children's matters and to have a similar regime for property matters. This would require legislative amendment, and there will need to be exceptions, and the exceptions that are proposed in the discussion paper are listed there: urgency, complexity, power imbalance, non-disclosure, delay or frustration, or allegations of fraud. So the discussion paper invited commentary about the appropriateness of those exceptions. So the idea is that parties will be required to lodge a genuine step statement and to articulate how they have complied with the obligation to attempt FDR for property matters prior to their case being allowed to be presented to court. So the second area, lawyer-assisted FDR. So the proposal is to increase support for legally assisted dispute resolution. You'd be aware that there is a number of pilot projects, 8 I think in the FRCs at the moment, for legally assisted culturally appropriate dispute resolution services. These pilots are currently being evaluated. The House of Representatives Standing Committee on Social Policy and Legal Affairs, affectionately called SPLA, recommended that, subject to a positive evaluation of the pilots, the Australian Government should expand the availability of lawyer-assisted dispute resolution. And I think as part of the recent announcement was that the funding for legal aid commissions is actually to help them provide more lawyer-assisted property dispute resolution. That's part of the announcements made in the last couple of days. In response to the questions about the greater availability of lawyer-assisted dispute resolution for matters involving family violence, there was a substantial number of submissions that supported lawyer-assisted dispute resolution for both property and parenting matters and financial matters. So there will need to be some level of detail in the reforms, and the proposals talk about situations when lawyer-assisted shouldn't be applied, how you engage in effective screening for assessing and responding to a range of risk issues. Obviously, it's very important in family violence cases. What the roles and responsibilities are of professionals, how you have a culturally appropriate practice, and how you provide services to LGBT clients and to families affected by disability. I'm getting towards the time at which I would like to allow you to ask questions, but I'll just spend a little time on some of the suggestions around courts. Basically, the suggestion is that too important and too expensive judge time is being taken up with case management functions within the courts. And the proposal is that we have a team of family consultants and registrars who undertake a triage and case manage clients that come through the courts and take some of the case management workload off the judges to allow them to focus on their role as decision makers. There's also a suggestion for specialist court pathways for small property matters. The argument again being that it's too expensive for people with not many resources to use the courts to resolve their matters, and there needs to be special pathways for those with small property pools. There needs to be a specialist family violence list, and there needs to be a specialist Indigenous list. Another area of interest perhaps to this group is the idea of a post-order parenting support service. Now, this proposal addresses concerns raised with the ALRC about the high rate of families returning to court following the making of final orders, as well as complaints about the costs and stresses of responding sometimes to many enforcement applications. This is a reform that's dear to my heart. I think the current system that we have, it's based on a criminal justice system which deals with cases as if they are single events. So everyone builds up in order to resolve a particular matter that comes before the court, and that matter is resolved, and it's sort of assumed that would be the end of it. But it turns out that clients that are experiencing separation, particularly high conflict clients, have what we call enduring conflict. Their family issues are constantly changing, their family environment's constantly changing, and they're constantly coming back to the courts and to the family law system in order to resolve ongoing disputes. And so the idea is, and this is something that's been trialled in overseas, in Canada and North America, I think they call it parenting coordination, the idea that you have someone who can work with clients after they've had a court outcome, and that person gets allocated. It's a court referral or a court order. It's not voluntary. And those clients have a worker who sits with them, helping them resolve ongoing disputes as they inevitably occur after the settlement of their case. This came about also from research from the Institute of Family Studies, I think 2015, where they looked at all cases that had gone through the court and found that 4 out of 10, nearly half, were repeat attendees. So nearly half the cases that had come to the court had already been there before. So this idea that it's a revolving door, and there needs to be a mechanism for assisting these people without requiring them to re-engage with the legal process. So probably the most interesting part of this is that the suggestion is that the person who is the worker has some decision-making authority to resolve matters. So there's a quasi-arbitration component to their service. The thinking is that these people would be more likely to be social science qualified, highly experienced in working with the family law system, and highly experienced working with clients who are in high conflict. This is an intervention for clients, families that are designated as high conflict, repeat users of the family law system. The idea is that the Family Law Commission, which we may have time to talk about today, we'll see how we go, should develop accreditation and training requirements for the workers in this area. Children and young people, I'd like to just spend a moment here. The ALRC is proposing that children are given an opportunity to express their views in court proceedings and family dispute resolution in matters that concern them, subject to ongoing assessment and management of risk. The evidence is clear that children want to have a say in decisions that are being made about their care arrangement. Research on children experiences in family law processes has also suggested they're unhappy with the level of involvement that they're currently getting. A 2018 research study by the Institute of Family Studies that was recently published, called the Children and Young People Study, looked into the experience of children and young people in separated families and has summarised the findings of a substantial body of family law research in the area in both Australia and overseas. And it's established the importance of children and young people having an opportunity for their views to be heard and considered in decision-making that affects them. In particular, the research has highlighted the importance of facilitating these opportunities to be heard, both in relation to matters relevant to deciding the post-separation care and regarding the more general effects of their parents' separation. The AFE study found that for a substantial portion of the children that were included in the study, the approaches adopted by the service professionals with whom they interacted operated in a way that limited their practical impact or effect and marginalised the child or young person's involvement in decision-making about their parenting arrangements. And the children were clearly stating they would have liked to have had more time. And I'm actually out of time, I note. 1 minute, I'd just like to say there's a lot more to be talked about, and it's in the discussion paper around how you manage that, how you assist children to express their views, what the risks are, how you take into account safety matters, because it's not an easy task. But there's one other role that's been suggested that needs to be included in the family system, and that's a child advocate. A child advocate with a social science training and expertise in child's development, who work with children to support their participation. So these are for children that are in court, who assist children and act as an advocate for the child during their participation in the court process. Maybe assist the child to express their views. If the child's not willing or it's not considered safe for the child to express their views, then the child advocate expresses the views on behalf of the child with the child's permission and ensures that the views of the child are communicated to the decision maker, and also keeps the child informed of progress and explains the outcomes. Many children talked about how they had no idea what was going on, they were getting different bits of information, they'd be asked about their views and they'd never find out whether they were taken into account. They'd be being told different things from their parents, one parent and the other parent and other people assisting in the system. So this is an idea to have a person assisting children to inform them as to what's going on during their engagement with the legal system. So thank you. I haven't had time to look at the idea of having an overall governance. That's in the papers. I commended to the idea being there needs to be an overall body that has a governance of the entire system. And they're calling it the Family Law Commission. Thank you.
Thank you very much, Andrew. We are right on time, but I just wonder if maybe one quick question. Reflecting on the principles that you mentioned that were informing the review, and you might recall, a lot of our members would recall last year we launched the research report Strengthening Prevention and Early Intervention into Family and Relationship Services, and we looked at using a public health lens in that work. So very interested if you have any quick comments on how that approach has found its way into this review as one of the principles.
Well, I think it's a self-evident approach, really, that if you're looking... part of the problems we've had in the family law system is that we have looked at it many times through unique lenses. So we've looked at the court system, we've looked at the support services, we've looked at how people access courts, how they get advice, how they access FDR. And the idea that I think has come through clearly is you have to look at the whole system. And so when you have a reform of this scale, you can do it. It's a systemic approach. And that allows you to actually cast your view and your vision across the entire experience. And I think the advantage of the public health approach, as I said, was to actually look at all people that are accessing or needing to access services and having a response that suits all of them, and the idea that you can shift the entire at-risk population. So what this would have as its ultimate game is to have less people who need the courts, because you've shifted the secondary and the primary services so that there's less impact on tertiary services. You don't ignore any of those systems, but you look at how they work together and try and shift the entire population.
Andrew, thank you very much for joining us today, and that's very informative, and the opportunity to have you here as in your capacity as a ALRC Commissioner has been very, very invaluable for us. So many thanks, and would you please accept this small token of our appreciation. So can you please thank Andrew.